Now on our top story, after the Prime Minister released the Solicitor-General's advice regarding Scott Morrison's secret appointments to 5 portfolios. We're bringing in live now Donald Rothwell, Professor of Law at the Australian National University. Professor, really appreciate your time. Thank you so much. What is your read on the Solicitor-General's advice released today? What stood out to you in those 29 pages?
Well, there's a very clear affirmation that the appointment of Mr Morrison to the relevant ministries was legal, it was constitutional. That's the first point. The second point is that there's no issue at all in terms of the capacity of the Governor-General to reject the advice that was given, that he swear in Mr Morrison into the relevant ministries. And it's made very clear there that any suggestion that the Governor-General could exercise reserve powers to refuse that advice is not consistent with the way in which reserve powers of the Governor-General could be exercised. And then the third point is that in light of the issues and the irregularities that predominantly came to light as a result of the fact that there was no transparency associated with these processes, a number of recommendations are made as to how these issues could be rectified.
Because when you do boil down the legal speak, the Solicitor-General was clearly unimpressed when he talks about the actions not being consistent with good government. And as you point out, he's saying that's why reforms are needed.
That's right. And clearly the Solicitor-General has been very conservative and somewhat cautious in his advice. He's not seeking to enter into the political fray in relation to that. But he does make some important observations about responsible government, the way that responsible government is embedded into Australia's constitution, and makes a number of references to the way in which the High Court of Australia has previously reaffirmed that and spoken about that, and talks about the way in which a Prime Minister being appointed to multiple additional ministries without there being any transparency about that, without the Parliament being aware of that, and without other ministers being aware of that, is not consistent with the principles of responsible government deeply embedded in the Constitution.
So considering the legality of Mr Morrison's actions that was described by the Solicitor-General today, does that mean we shouldn't expect a slew of legal cases to test this in the courts as a result of Mr Morrison's decisions to take on those portfolios in secret?
Not necessarily, and I think the first point to note there is that the Solicitor-General wasn't asked to investigate that particular issue. All that he was asked to investigate was the legality of Mr Morrison's appointment. Whether or not other parties who are considering actions taken by relevant ministers during the time that Mr Morrison occupied multiple different ministries from the period in March and April 2020 until the time of his government ending, whether they seek to challenge some of those ministerial decisions in the courts is really up to them. But on the basis of the advice today that's been released, that doesn't necessarily give them any comfort in terms of being able to develop those arguments, but that doesn't mean to say that they can't consider separate legal issues that haven't been raised in the Solicitor-General's advice.
So, Professor, are you happy to hear the Prime Minister say that someone with a serious legal background will be appointed now to run that independent inquiry? And what would you expect the upshot of that will be in terms of what specific reforms we can expect?
Well, that's really going to be a political inquiry to a degree, because it's going to be conducted under the auspices of the government of the day. It will have a much wider brief than that the Solicitor-General had. But most importantly, the Solicitor-General's advice does contain a number of recommendations in which some of the issues that have been raised as a result of this incident could be addressed. One of them, which the Solicitor-General only briefly touches upon, is the potential for the Parliament to enact new laws to seek to resolve these issues. And I think that will be a critical issue that would be under consideration for any inquiry that the Prime Minister appoints to conduct in this issue.
Professor, just finally, just picking you up on a point you made earlier about how rare it is for us actually to bear witness to the Solicitor-General's advice on any particular matters. Do you have any concerns about the decision to release it in full? Was that the right call, do you think? Could that have actually impacted the way the Solicitor-General did frame the advice?
Look, it needs to be acknowledged that it's absolutely exceptional that a Solicitor General's advice would be released into a matter relating to a former Prime Minister and a serving Governor General. So this is really quite rare in Australian history, I think. No doubt the political events are also very rare, so we need to acknowledge that. The advice, though, has been very narrowly framed, and ultimately the Solicitor General has done an excellent job in answering the question that he was asked to address, but I don't think it creates any significant implications other than the key recommendations that are coming from it.
Professor Don Rothwell, we always appreciate you joining us with your expertise. Really appreciate you making the time. Thanks so much.
You're welcome.